Ladies and gentlemen of the jury.
Have you reached a verdict?
Welcome to the John and Jordan on Justice podcast, your weekly deep dive into personal injury and wrongful death law.
All rise.
Touching on everything torts, legal tech, trying cases to verdict, and the outlandish stories that come with them. And now, here are your hosts, John Fisher and Jordan Reed David.
Welcome in, everybody, and welcome to the next episode of John and Jordan on Justice. Today, we are joined by a special guest, Tiffany Devereux. She's the founder of Jury X, a jury and voir dire consulting company that we have used in our firm with tremendous success. And without further ado, Tiffany, how are you doing today? Thanks for joining us.
Doing well. Thanks a lot for having me.
So, as you know, John and I, we're primarily based in Florida. That's where most of our trial cases are. We're doing predominantly single plaintiff personal injury cases. And before Jury X crossed paths with us, John and I used to shake a magic 8-ball and say, is this prospective juror good? And that worked pretty well, but your system seems to work a lot better. John and I owe a debt of gratitude to you and your team, specifically Mary Sheedy, who came down in person to a trial we had in Miami a couple of months back that resulted in a multi-million-dollar verdict. But can you give some insight, starting maybe with a broad overview of how Jury X is approaching the problem that is jury selection and the value proposition they add for trial lawyers?
Sure. Jury X helps attorneys identify biases in potential jurors using artificial and human intelligence. And so what that specifically means is during voir dire, we are helping attorneys by looking at the potential jurors' social media and public records. And we're doing this, while you guys are questioning and throughout the day. And we score these potential jurors. And by doing this, we are able to create what we call a strike priority list for you guys to eliminate those jurors who are not open to hearing the plaintiff's arguments in your case.
That's good. Yeah, I thought it was pretty effective. I'm sorry, like what you guys do, from a trial lawyer standpoint, is incredibly scientific. Not just picking out a hat like we have done in times past.
Yes, and so how we've done this, how this process evolved is, my brother is an attorney. He is based in Florida, and he had these tobacco trials. And so I was helping him on kind of more doing evidence research. My background is journalism and photojournalism. I have a master's degree from University of North Carolina at Chapel Hill. And we are based here in Chapel Hill. And so what I figured out for Greg's, it was Greg Prysock as my brother. What I figured out for his cases was if we could look at specific information on each potential juror and rank that information according to this matrix that I developed over time. And what that does is it tells us basically who's on our side, who's not on our side, and then which person we need to eliminate based on kind of degrees, if you will, of influence that they may have on the panel. And so it was effective in these tobacco trials. And then we ended up broadening that to other PI cases across the state of Florida. And then we went on to other states as well. We were able to, in Florida, you guys have special laws for public records. And as a journalist, that was one of the things that was like the first thing that I started looking at was what available information there was in Florida. And so one of the things that we were able to do is, collect some large databases that are regularly updated. And so we were able to create some programs that gets some information ahead of time, even before voir dire starts, even before we know the jurors, because we do it on everybody who is summoned. And then once we find out who is going to be in your courtroom, then we use some of the human intelligence comes into play on the information that we're gathering and looking at.
Yeah, it reminds me of this idea, like, I mean, all this data is out there floating around and people are free to ignore it, or maybe they don't even actually have the ability to figure out how to pick it out of thin air, so to speak, and interpret it. But you guys seriously have seemed to crack the code a little bit. I want to step back because just a little bit in the process as a trial lawyer, I think most lawyers who are preparing for trial, you know, they're ready to walk into the courtroom on day one of voir dire. They're ready to rely on mostly their experience in past trials, of which they're making kind of judgments in a stereotypical fashion about people's profession, ethnicity, you know, education, etc. They're relying on their intuition, their gut. I know for years when I did mostly criminal, that was where it all fell. And then I think for years, even before I started practicing, there was this growing sentiment of you can focus group your case. You know, you could preview it to a room of strangers who will never end up actually sitting for you, but should theoretically give you an insight into who it would be an ideal juror and all that. But you guys are different. You guys are on the front lines. You're kind of, you know, walking into the trial the same day the lawyers are. Maybe you get a questionnaire with their names a little bit in advance. But, you know, generally speaking, you're coming into it fresh and without a bunch of information, and you're able to just quickly digest, interpret, and kick out this meaningful data that you can make decisions from. I'm sure that wasn't an easy process. There was probably a lot of trial and error, I bet, right?
Yes. So when I first started this, so Keith Mitnick is one of the attorneys with that was partners with my brother at Morgan and Morgan, and so Keith Mitnick was, really helpful in pointing me in some, like when I would have a question about, oh, would this be something that would be desirable or less desirable? So he was really helpful in answering a lot of my questions. I did do a lot of academic research into the history of jury selection and, jury consultants essentially, and how long they've been around and what the processes have been in the past. And then going from there, and one of the things that it's just really categorizing and thinking deeply and taking sociology, theories and bringing it all together for jury selection. And I don't think that that's been done to this level. Jury consultants certainly have a lot more experience as far as, understanding the psych, because a lot of times they're psychologists. And so just understanding how, when a person, is responding in court, they're great at analyzing that. However, what I feel happens is a lot of times people may respond in court, but they're also taking in kind of like a mob mentality. They're listening to what others have said about their views on whatever the question was. And it may be something that they have never thought of before, such as, should there be caps on damages? And obviously, that's a question that a lot of attorneys ask during civil litigation. And, a lot of people have not thought about that. Should there be a maximum? And then somebody else answering that before it's their turn to answer may influence their answer in court. However, when they are back with their own thoughts and thinking about your case and how much to award and that type of information, they may not actually, feel that there should be caps on damages or vice versa.
Right.
And so by looking at a lot of the other information that we find about them, that they have said about themselves, that they have described on social media about social issues, we're able to digest a lot more of that information than is presented in court, and come up with an analysis on how that person would likely respond in the jury room.
Yeah, I thought,
Go ahead, John.
just in our personal experience in the last trial, and for those individuals who haven't thought about bringing a jury consultant live, do it. If you have the case, the energy it takes to get to trial, you want to be there with all the resources that you can have. And Jury X, for us, interestingly, they were pretty spot on, right? There were a juror that they thought was going to be one of the, for us, but a leader in the group, right? You want a leader, maybe one or two, and then some followers, right? And if they're bad, if they end up being a follower, it's okay.
That's exactly right.
Right. So we had the leader that you guys wanted, and then there was another person that Jordan, I think Keela, were like on the fence, gut, didn't necessarily want. Didn't really have an opinion either way. Mary said, put her on the jury. Well, what happened? She ended up being the foreperson, and she ended up being the one keeping the number up. And the leader, the leader was the leader, but he kind of held the rest of the people and then submitted to who was ultimately the foreperson to reach like a compromise.
So what I kind of think of is happening in the jury room is, we everybody knows that we need a foreperson. We need a leader who is going to organize everybody. We need somebody who can be persuasive enough to bring people over to their side. And of course, we want that person to be open to the plaintiff's arguments. And so once they are in the jury room and making these decisions, we also need somebody who I call, I kind of started thinking about them as like the whip, as we have in Congress. So the person who gets everybody else behind the leader. And so by doing that, now you have two people who are supporting an argument one way or the other. And then everybody else who are those followers are falling behind, or, falling into line. Now, with the followers and whether they're good or bad for us, and that not mattering, the reason why, we want to keep some of those because, the strategy is that we only want to have one or two leaders. Primarily, we'd like one strong leader and then one more supportive leader who would be the whip. And then that will block out a lot of the other potentially bad leaders that may come into the panel. So I think in your case, there was like a lot of an undesirable number of attorneys that could have been in the panel. And I think it was like 10% or something from the venire of the people were attorneys. And so, sometimes they're good, sometimes they're bad. Right, a lot of times people want to eliminate them. Right. And so by having leaving this woman on that we did, who did become the foreperson, we were able to block one of the other, I think it was a person that would have been a high level leader and very influential and probably bad for you guys.
Yeah, no.
Yeah, I think the outcome obviously validates the methodology. Obviously we were deferring to Mary substantially, if not exclusively, and it worked out favorably. But on that point of being able to defer to Mary or whoever it is from Jury X that's going to be in the courtroom with other clients, other trial lawyers, what I found really meaningful for me was so often if John's doing the questioning and voir dire, then I'm doing the note taking, and so is Keela, or whatever. You can just interchange us. And the people who are doing note taking, we're really trying to take good notes, including timestamps, right? We're trying to prepare for cause and parents, and it doesn't free your mind up, because we can't multitask that well, to really be engaged, or at least as a listener, to be an active listener to every last thing, or maybe pick up on body language cues when John's talking to one prospective juror, but another one's starting to shift in his or her seat. By having Mary there with the live feed transcript from the court reporter, even if she didn't, she's taking copious notes. It gave me the confidence to say, hey, I don't have to do this. I can be in the moment with John, maybe pass him a note on something to follow up on, whatever. And I found tremendous value in that, which I don't normally have, because it's not the same value as just bring someone from your firm to take notes. That's not what I mean. That's not a 1-for-1. This is, you can defer to someone who's taking notes with a purpose, and who's going to, that's part of the methodology. And that really allowed me to do what I do best, I think, which is be available to John in that particular scenario.
Yeah. And I think with you guys, the benefit, we did live, I forget when they do with the court reporter. What is it when they take
live feed?
No, there's another real time.
It's real time.
Real time.
Yeah, real time.
And
We call it remote access to real time because we like to have it in our office as well.
Correct.
Because we are also taking copious notes in our office. So not only is Mary taking notes, you're taking notes, but we're having somebody take notes so that if somebody says something that's a cause challenge and we know we're going to be able to get them off, we don't have to invest that time into that person. We can continue looking at other people.
well, yeah, we took a break, and Mary, when we split for lunch, was like, "Look, these people you can avoid, they're already gone. You got to talk to this person, follow up on this issue." But what I thought, to Jordan's point about giving confidence, is I don't get the chance to talk to everybody. Sometimes I do, or sometimes I don't have a lot of information. But with Jury X, you guys doing this stuff on the back end, we can at least have some information on a prospective juror if they were number, 48 that you don't think you're going to get to, but you end up getting back there, that you may or may not have to ask a lot of questions to. So I found that to be extremely helpful. Or if I was on the fence, I didn't, not to say we do away with our own note and feeling, but it gives you that ability that if you're just on the fence, you have the science, it works, and it worked well for us. So, it gives you that ability to trust it. So
yeah, one of these things too, just like I've been thinking about ever since we've used your services is, well, I've been thinking about this particular point ever since I've been a trial lawyer, but more recently through the lens of using your services. For years, you'd walk into a courtroom, everyone in the panel, of prospective jurors, they're strangers to you, or they should be, and almost always are. And you're basically spending however much time the judge gives you, asking them to do public speaking, number one, about themselves and their innermost, thoughts, honesty, and bias and prejudice they have. It's so antithetical if you think about it to how you would expect an environment to be created for someone to openly share the truth about them. And so you can only take what they say with a grain of salt, I think, in that scenario. You're going to have people who are deathly afraid of speaking, public speaking. It's right, the number one fear. You're going to have people who love to hear the sound of their voice and you can't get them to shut up. But with your services, you get this ability. Okay, what they tell you in the courtroom in public is one thing. I think you even use this phrase, so I'm going to borrow it for you. It's just, let's see how they describe themselves outside of the courtroom, but still in public. How do they hold themselves out on social media or some other place where they are holding themselves out to the public? That's perhaps the most meaningful data that you're going to get. And I'm sure your system accounts for that appropriately.
Yeah, and that is exactly what we are trying to do, is find out, because you guys have limited amount of time. Sometimes you guys have a couple of hours. We've gone into, federal court where they have 15 minutes. The judge does voir dire, and maybe the attorney has 5 minutes of follow-up. They might extend it to another 5 minutes. And the other thing that, I don't think that really is thought about that much is, you have these people, and one of the things that we are trying to do is get people off for cause, right? And so we're trying to get people to tell us that they're biased. And then you have this judge who's sitting up there, on the judge, in the judge's bench, and they've got the pomp, they've got their black robe, and then they are asking, oh, but can you set aside your biases and in this case and listen to this case? And of course, you guys try to get it in the person's head. Hey, you know what? Everybody has biases. It's okay. But it's also very hard for a lot of people to tell a judge, no, I'm sorry, judge, I can't. I'm biased. And, nobody wants to be biased. Everybody wants to have an open mind. And then especially to a judge who that's what they do for a living. And then as far as the background information, I think that one of the ways that we are different is that there are other companies out there who, they have come to this space from a technical background. And so they are applying technology to the legal industry and to jury selection. And it doesn't necessarily transfer over exactly. And so what Jury X is we have done this organically. So we have approached this from a legal perspective and grown into the technology and found out what technology and what resources are available out there, so that we could use that, harness it. And, there's a lot of data that we are able to gather. Some of it is just noise. And that's the other thing that a lot of people don't really understand is that, I don't care how many times somebody posts about their dog. I don't care that somebody is volunteering at an animal shelter. That does show a little bit, some compassion. However, that doesn't necessarily mean that they're going to be open to your argument. And so that's what we're looking for first and foremost, and then also who is going to have the most influence. Right. And so by approaching it this way, we're not only looking at what is happening in the courtroom as the traditional jury consultant would do, but we are also bringing the technology in and harnessing the availability of, just the latest information that we can use in the latest programs to combine that. And that all comes into our matrix that helps us decide quickly, the best jurors for your panel and the ones that, are least favorable.
Yeah, I loved it. I mean, I can't wait for the next trial so we can use you guys again. I mean,
I know we had one settle out after we used you, but we were ready to use you in a different county, in Alachua County.
Yeah, we had 2 cases, and well, hey, maybe it's the good jury verdict you got for us working with you that now no one wants to see us in trial. They've settled out. We settled another one yesterday that we were going to use you on, and it's great.
Yeah,
it's a quiver. What is it? Is it a bow in the quiver? Am I saying that right?
You should put an arrow in your quiver and shoot it with a bow.
Arrow in my quiver. No, for jury selection, I look at it like, not only that, it was fun, right? Like, look, Mary, we worked with Mary. She was fun. Like, it was very, you guys came early before trial. We met, talked about the case. We actually had done focus group work. We gave that to your team. So you kind of had an idea on the back end of who are we looking for as well, dissecting that data, right? While we allowed to just prepare, get ready, do what we need to do. And I think it's a tremendous asset to have a team like yours working with us hand in hand. And, I see the posts. I don't know if it's a lot of times in LinkedIn, verdict after verdict after verdict after verdict, working with Jury X, that the having good results. And so I see it's obviously working.
It's really rewarding. And, the reason why, in addition to helping my brother, the reason why I wanted to do this is because, I know that there's a lot of powerful insurance companies, powerful corporations that are out there, and they have, I believe, a little bit too much maybe money in politics. I think that they're influencing our laws a little bit too much. One of the things that I'm really focused on is social justice. And that was, that's something that some journalists want to help out the world. And that was what my goal was going to be, was, I was going to save the world through photojournalism and through feature writing and investigative journalism. And I found that, I wasn't able to work in that industry. I'm a mom and I wanted to own my own business. And so I didn't want to be a freelancer. I didn't want to work all by myself. I really find it fun and engaging to work in the courtroom with our attorneys. And we add a lot of value by doing that. And then, working with a team of people who are really smart, who've contributed a lot to the company over the years, as far as being able to categorize potential jurors in ways that other companies haven't been able to do. And so it's very fascinating. And then also, continuing to educate ourselves in sociology and finding out like the latest as far as like, I had one client who was like, I don't like millennials. I don't like them. I don't understand them. And so that's something that we kind of did a deep dive into to find out like, what is going on? Why are they slightly different than what would seem to be so true for a Generation X or a baby boomer? Why are they so different? And so that's the type of thing that we really love doing at Jury X. And the other thing is that it's just a lot of fun. I mean, it really is a lot of fun.
So Tiffany, obviously having worked with you, I have the benefit of knowing kind of how the sausage gets made, so to speak. And I know that it's not just like this one size fits all solution. You guys have a multitude of tools at your disposal, and you kind of leave it to the attorneys, which I think is the appropriate way to say, look, we can help you in 10 different ways. Here are the 3 we would definitely suggest, but there's these other things like in-depth profiles, for example, that are kind of an add-on, but I found value in. Can you kind of educate the listeners out there to that?
Yeah, sure. So one of the things that we really focused on early on is, as far as our process is, we don't want you guys to change anything how you are approaching your voir dire. There might be a couple of tweaks if there might be a question or 2 that we would like to see. But as far as, if you've been doing jury selection, if you've been going to trial, we would like for you to continue your process because you figured out something that works for you. And we like to just be able to plug in. And that's why we come down the day before, and we just want you to be comfortable with our scoring system and understanding that. But then once we seat the jury, we also are very focused on how you communicate with that jury. My background is journalism, and before that I was in advertising. And so that is very much focused on how to communicate with your audience. You have to keep in mind who your target audience is. And so on your case, you have 6 jurors and sometimes 1 or 2 alternates. So you have, up to 8 people that you really need to focus on. And you're going to have to communicate a different way to different people in that panel. And so if you have somebody who is very methodical, who's very detail oriented, you might need to have a little bit more precise evidence. Whereas if you have somebody who's more into the bigger picture, you might need to just discuss and not focus on the details, but discuss the broader implications of what happened when the person was injured, and how it, and of course, proving your case. Right. And so that is what our in-depth profiles do. We give you a snapshot of exactly who that person is, because we don't really have time to do that during voir dire because we're looking at so many people. But then once you seat those jurors, then we're able to go back and say, okay, this is who this person is. And these are some things that you might want to think about when you're communicating to them. And sometimes we've had attorneys who will actually, we one of the things that we say or show is how they speak to their peers in social media. And so if somebody is communicating with them and they're responding back, that is something that we will clip and give to you guys. And what that does is it gives you, are they using, a lot of current vernacular, like a lot of slang, or are they very precise in their grammatical expression? And so I had an attorney one time who was in a small remote town, and the jurors were not very sophisticated. They were not very educated, and the ones that were on our panel. And so I asked the guy to tell me about his opening statements, and he started sharing it. And I said, just hold on a second. we need to bring this down a little bit because you're going to be speaking over these jurors' heads. And that's something that we all do sometimes. If you've got a specific education or specific knowledge in something, we're using terms that other people may not understand. So just making sure that we are speaking to our audience is one of the most important things, I think, in these trials.
Yeah, it's not like, obviously, once jury selection's done, the in-person rep leaves, but the data remains. And even for that matter, for us, Mary remained available because in the one case we used you guys on, I don't know, it was bled into a second week of trial, but at some point during trial, there was the potential due to something that had happened for one of the sitting jurors who was not an alternate to have to be excused. And then the question was like, well, there's two alternates sitting. Which one do we prefer to the extent that we can do that? But Mary was available. And even then, so now we're mid-trial, but here we go, hearkening back, and there's no guesswork. It's not just like, well, everyone's an alternate. I guess we were satisfied, put them on. There was even a preference there. But I want to get back to something John said. He didn't use this term, but, Tiffany, you've said you guys have a scoring system. Obviously, I've been there. I've seen it. John talked about the experience he had working, hand in hand with Mary during selection. And as the person who was there to kind of observe it all, I do feel like there's a bit of a gamification feel to jury selection. So it used to feel kind of just shooting in the dark a little bit, but now with the scoring system, it actually feels a bit like a game. And I don't mean that to make light of it at all. But it just feels easier to play through that process, knowing that you have a scoring system that you're relying on. Maybe this gets back to the original concept of just having confidence in who you're ending up selecting, because there's a numerical value or some qualitative value that you guys have ascribed to these people. And just like a game would have it, you're just like, no, this is a high score. This is who you want. Removes a lot of the doubt.
Yeah. Well, I feel comfortable, telling you guys that our scoring process is from a -4 to a +4. And, and there's varying degrees. The -4s are people that we don't want. The +4s are people that we do want, because we think that they're going to be open to the plaintiff's arguments in this case. And so, making sure that our attorneys understand that and how these different scores interplay is really important, because it becomes a priority strike list. And then, we're able to strategize within the panel how we're going to use our strikes, especially in Florida, where I think that Florida has, not every other state has the same system that Florida does. I think that Florida has the best jury selection system if the judges use the ones that are, the majority of the judges do use. And that's, it makes it more of a strategy. And so it's a lot of fun. And in the past, so in our office, we have a large research room where it's, people are around in large conference room, if you will. And we have a big screen TV that's up, and we have the transcripts on there. And so we're reading, sometimes we have somebody that's doing the transcripts and taking notes from that. But then sometimes we're just looking up and seeing where they are and what the judge has said, or what an attorney has said, or, oh my gosh, can you believe that this juror said this? And then when it comes to what we call the peremptory series, it's a little bit like a sporting event for us, because, we're kind of cheering our clients on eliminating potential jurors. And when defense eliminates somebody that we didn't like, we literally do cheer. We're doing, fist pumps and stuff. So it is a lot of fun for us. And it's also very meaningful to everybody that works at Jury X, in order to kind of level the playing field, if you will.
Yeah, Florida has some of the best jury selection process. I read some of these things that are different in different states, of different, even the basis to get someone excluded for cause is great in Florida. We have a reasonable doubt standard. If there is a reasonable doubt as to their impartiality, we err on the side of exclusion, right?
That's right.
Some states it's like a much higher standard than that. It has to be like, almost confirmed they will be biased and never, not just like maybe, because if we even get those jurors that say, well, I think I can exclude it. And I asked this follow-up question, and it's actually from Mitnick, and he says, well, some people, when they say I think, they mean 100% they're sure or about their 90%. So when you say I think, you're about 90% sure it won't affect you. And they're like, yes. Well, that you're out. You got 10% that thinks it's coming in. That's reasonable doubt. So it's a very effective, good system here. And it is like gamesmanship. Not gamesmanship, because I don't want to suggest we're like playing the odds, but when it's a back and forth strike, what are they going to do? Who are they going to strike? And we were telling the story off before we got started that in this trial, they struck one of the people we wanted off. Mary was, hitting my foot under the table because we were excited that we got to save a peremptory for someone else. So it was like really good. We had the notes. We knew we wanted them off. We were going to have to use a peremptory, and they did it themselves. So it's very, it's a fluid, fun system. Obviously, we're putting in the work, asking the questions. You got to get the juries to participate. But with that information and the data, you guys in your back office, the live in support in trial, I mean, it's a full-faceted approach to jury selection, and I loved it. I do have this question. Your home office is in North Carolina. So what states are you operating? I mean, essentially, you probably can operate in every state, but...
We do.
Yeah.
Okay. So we have done cases in North Carolina. We've done them in Georgia, Tennessee, Kentucky. I mean, California. We do a lot of cases in California. We've got one coming up in Texas. I think maybe Arizona. We've done more than 450 trials. I can't keep track of them.
That's great.
I started this business, and I think the first case that my brother tried to get me to help on was in 2013. So 2014 was like, I think I did 3 cases that year. And, getting back to what you were saying about the strategy and when the other side dismisses somebody that we think is good for us, sometimes, people are like, why would they dismiss that person? I mean, look at the information that we have on them. It's so awful. Of course, they're going to be bad for us. Why would they do that? And, it really is so helpful to have this background information from outside sources, because they have no idea how great that person could have been for them. And so I wonder, a lot of times people are using paralegals who, are helping them on the case as well as trying to do research on these potential jurors. And so and it's not that the paralegal doesn't know who they want. It's just that they're not able to get to all of the information that we're able to, because we do this, week in and week out. And so sometimes, going up against tobacco companies, that's what I cut my teeth on, as far as developing this system. And so you have to be fierce, right, against those tobacco companies, because they've been using jury consultants since the 80s. And they use a very large team, and they, sometimes they do it on every person that was summoned. So I guess that kind of competition just made me want to focus on exactly the types of jurors that we would want, who we think are going to be open to our argument. And so, at the end of the day, I think that we've done like 49 cases against the tobacco company, and we've lost 4 or 5. So that's when I am able to demonstrate that this process is repeatable and it's scalable. So, we do multiple cases a week typically. So it's great.
I think your last comment about going up against tobacco and they've been using jury consultants or something similar since the 80s, that really breathes air into what I think is the larger point that many people probably are thinking about, but they're not really doing anything about, meaning we should not presume as trial lawyers that just because you're going into trial in what I'll call a routine automotive crash case, that the insurer on the other side has not invested in jury research, jury consulting for their team. I don't think you can make that assumption. I think if anything, it's foolish to do so. And this gets to the ultimate value decision for the trial lawyer, because this is not it's not cheap or inexpensive to hire you guys, nor should it be. But this gets to the whole cost benefit and if it's worthwhile. I think if you were to survey most trial lawyers nationwide, the consensus would be jury selection is the most important or second most important thing. I think it's the most important. Well, if that's true, and if you pick the wrong jury, then you're from opening to close and all your beautiful exhibits and all your well-paid experts, they're talking to deaf ears and showing to blind eyes, right? I mean, that's how I even found you. John and I had tried a case in Lake County. We picked a terrible jury out of a terrible pool. And even though it was a quote unquote plaintiff verdict, it was a loss, a horrific loss. And you reached out to me on LinkedIn after seeing a post, and you were kind enough to do some kind of free debriefing. And that's what kind of cued me. And I'm like, what are we doing here? We work these cases up for years. We want to get these cases to trial. The client deserves a good result. And then even though we know jury selection is the most important thing, we're not willing to invest the money to get it done. And I mean, John and I will never go back. I mean, we're kind of like, we're converted, so to speak. But I think for the people out there saying, well, I don't have the money, how do you know? It's like, as long as you think it's the most important part of trial, then that's where you should be investing. Right. You know, take some of the money you were going to spend on these fun animated visuals, maybe, or the expert that you probably don't need to come live, and allocate it over to a company like Jury X and see over, 2 or 3 cases, if you're going to get it back. I think you'll get it back 10, 20, maybe even 100-fold. And so I just want to speak to the audience out there who has these reservations, like, oh, it must be nice to have the money to spend on this. It's an educated, calculated investment for the client. And I think to your point, you only lost 4 out of whatever 50 trials against tobacco. Odds are it's going to work out in your favor,
Yeah, it is, like I said, it is a repeatable process that is very successful. But, one of the things that my brother first said to me and why he wanted me to help is he's like, look, I mean, everybody knows that tobacco, started targeting children. They were marketing to children. They knew that nicotine was addictive. All well before, academia knew that. And it doesn't really matter. All it comes down to is whether the jury or the people in the jury believe that somebody has the right to sue the tobacco company. And that's really what it comes down to for every case. Just having people who are open to hearing the evidence on both sides. But a lot of times, the plaintiff's attorneys have their backs up against the wall, because so many people are anti-plaintiff friendly. So that's really, what we're trying to do is level the playing field on that. And, I know that one of the things that happened in Florida was the nursing home industry. They were being sued a lot, I believe, in the 90s. And, some people thought that they cleaned up their act, but really what happened, from my understanding, is that there was legislation that was enacted that allowed a little bit more leeway to their industry. And so, that's really not fair, because it's, there's not a lobby group for these people who are in the nursing homes, right. Or at least a very large and successful one with a lot of money behind it. And so by being able to level the playing field and finding jurors who are open to the plaintiff's arguments, I feel like, we're doing a little bit of social justice.
You are.
She's speaking right to you with open to plaintiff's arguments. That's how John talks all the time. I'm not that way. I used to be pro plaintiff, pro defense, or anti plaintiff, and John is more like you, Tim. You're just looking for people who are open.
I need
and
people
receptive.
that are open minded. If we have open minded jurors that are receptive to our arguments, I believe we're going to win every case. I 100% believe that. It's the ones that dig
I am
in,
with you on that.
Yeah, that say no. They're just like sitting in that corner, like, I don't care what it is. No one's paying me for my back pain. Damn ambulance chasers out there. And there's people that like that exist. And, we can flesh them out, get that information, and it's just a vital asset to anything. And I for one thing I want to add, if there's plaintiffs' lawyers, there are, litigation funding opportunities out there to help offset some of that hard direct cost of the lawyers for purposes of using services like this. So there's, if you have questions or anything about that, let me know. I can, put you in touch with some good people that can help facilitate that, because at the end of the day, if you're trying to do the best by your client, it's something that you should have, especially in new jurisdictions, that you guys can provide, that background information that we just don't have because we don't necessarily practice there all the time.
And that's another area that we're also able to help on. If it's a new jurisdiction, we're able to actually go in and do surveys. We don't do focus groups per se, but we're able to do, written surveys and find out more information about how this community would receive your case and your arguments. And the other thing with that is that, one of the things that I'm not crazy about on focus groups is that a lot of times they're not statistically reliable, and they're just not able to get, it's too costly to hire so many people, 100 plus people to come in for a mock trial. And so one of the things that we're able to do is get the surveys out to people, and we are very interested in mirroring the respondents based on the types of people who are more likely to be in your venire. And the reason why is because, sometimes if you're paying somebody like $50 or $100, whatever it is, to come in, you're not getting those high level influencers a lot of times who are coming in and telling you what they think about your case. And so this is one way that we're able to do that. And so those different communities, so if we've not even been into a specific area, we're able to go find some background information on these potential jurors who are going to be summoned for your case.
And I know we're obviously focusing on the jurors, prospective jurors, and rightfully so. But I wanted to share just anecdotally, now with the benefit of hindsight, I feel like there's a secondary, almost unintended benefit of using, Jury X. That's the only company I've used and intend to use. I'm sure there are others out there, but where it's like you walk in a courtroom, let's say you've never tried a case in front of that particular judge, and within 15 minutes or so, the judge picks up on, if not outright asks and confirms, who is this person? Oh, this is our jury consultant, right? And they're set up, they're there, they're dedicated, they're listening. They're a part of that process. Come time to make selections. Now, I'm not, judges are humans. If they hear our side with our jury consultant saying, Judge, at 9:48, prospective juror, ABC said this is why we're moving for cause. I feel like, looking back, there's a degree of confidence in that the judge probably has to put more. Yeah, that I think I do recall that being said. Let's err on the side of caution and exclude that one, because John and I have been in trials where we hadn't tried a case in front of that judge. We had no jury consultant. We're taking great notes, and then we get to selection, and we're like, Judge, this is what he or she said. I'm telling you, it's right here. And of course, the seasoned defense will, Judge, I don't remember hearing that. And in that environment, the judge leaned with the more experienced lawyer and said, yeah, I don't think I remember that either. Now, we want a new trial on that case, but that's 3 years wasted, really. And I'm not saying it's always going to happen that way. I'm not suggesting there's any undue influence, but I do think it shows, if nothing else, a commitment to the court that you're here ready to try this case to the absolute best of your ability. And I'm sure it also communicates a few things to your opposing counsel who maybe didn't know that you were willing to take the case as serious.
Yeah, the opposing counsel typically knows that when they see somebody that's on your side whom they've not seen before. I prefer to stay under the radar because I don't want them to necessarily know exactly who we are, because they'll usually find out right after the case is over, when they get hit with a big verdict. But by flying under the radar, I hope that we're able to make a better impact on the plaintiff's side. We only do plaintiff's cases, by the way, unless it's a First Amendment case, and then we're always trying to defend the First Amendment too. But typically it's only civil litigation that we're doing. So it's, we're very focused in this area. So this is like really what we're doing every week. And if a judge asks, who is this person sitting at the table next to you guys? We're okay saying who we are, like who are the name. We don't typically say the firm that we're from, just because we like to keep a little bit of anonymity there.
Yeah, of course. That's smart. Well, I know that the judge asked specifically in our case, was like, she like knew. She was like, is that a jury consultant? And we were like, oh yeah. We have a good rapport. And so that was it. Just was curious. But I think it did have that confidence for the judge when we made some of the cause challenges, for sure.
Yeah.
Well, I don't really have much else other than to just say, and I look, there's no affiliate deal here. If nobody ever hired Jury X to listen to this, it's not going to change my life. So what I'm sharing is really my own personal and professional opinion. But, I want to thank you, for reaching out after that one undesirable outcome, because I think you've already helped change the outcome of one of our clients' lives substantially. And I thoroughly believe that the next time we get to work together, you're going to do the same for that client. So thank you for that. But maybe you can let people out there know, where they can find you or who they should reach out to if they want more information to work with Jury X.
You can just go to our website, jury-x.com. And there's some contact information in there. You can also email me or call our number that's listed on there. My email address is tiffany@jury-x.com. And we would love to have you guys. We want to help as many people as we can, and we're trying to bring this to as many cases as we can. Unfortunately, because of our costs, it is a little bit more expensive. But what we typically have heard is if a case is over $100,000 in medicals or lost revenue, etc., then it's been worth it for them to use our services, because they were able to increase the verdict amount. And this is like statistically, I guess.
Yeah.
So just at brass tacks, if you're a trial lawyer out there or an aspiring trial lawyer, you're never going to show up to trial without an opening statement ready to be delivered, or with your exhibits to give to the clerk and the jury, or an expert witness to get you past direct verdict, whatever. So stop showing up to do jury selection by shooting in the dark. At least that's my personal sentiment. So
100%.
without further ado, thank you everyone for joining us today. Tiffany, you especially, we appreciate you carving out the time and bearing with us through some preliminary technical issues. And everybody out there, thanks for listening. We'll see you on the next one.
Yep. Thanks, guys. See ya.
Thanks for checking out the John and Jordan on Justice podcast. If you enjoyed today's content, consider leaving us a review and be sure to subscribe wherever you heard this podcast so you never miss an episode. For more information or to connect with John and Jordan, check out @OnJusticePod on Instagram and Twitter, or check out Discord for plaintiffattorneys.com to communicate with them and like-minded plaintiff attorneys in a private Discord server. Until next time, this is the John and Jordan on Justice podcast.